Good afternoon, sir. What's your name? Another ceiling fan. See a lot of those.
Good afternoon.
Good afternoon. We've got someone in here as AirPad 2. I'm not sure who it is. This door is Hamilton. Yeah, she's not set till later this afternoon. Good afternoon, Miss Hamilton. Can you hear me?
Did she get disconnected?
Well, she isn't. She's also AirPad 2. Her hearing isn't until 3 o'clock. She had logged in the middle of the night last night, I think practicing. So I saw that she had logged in. So I'd rather they gave it a practice run before 1 minute before showtime. So she's okay with that, but I can't hear her or see her anything but her ceiling fan. The O'Donnells are connecting. Our first case is Richmond and Jewell, and neither of those parties are here yet. We're off like a herd of turtles, but we've got a few minutes before our first case. Miss O'Donnell, can you hear me?
Yes, sir.
Yes.
Oh, it's both of you, okay.
Yep.
Do you have the ability to do video?
Yes, I believe so.
Can you see us?
No.
Ooh.
Okay.
There's a little camera with a slash in it, and if you hit that,
Oh, I see.
No, I don't think that's it.
Well,
It's probably on the bottom of here.
depends on what kind of device you're on, but
oh,
sometimes-
right here. I see it. Yep. There we go.
Oh, there. All right, very good. You're in the right place. You're a few minutes early, but you'll have a chance to watch the earlier case.
Okay.
So
Oh,
And your case is 125, but you're here in the right spot.
okay, good.
Trying to bring people in right now. There's one lady that's struggling, and that happens a lot.
Am I on here?
See your face?
I don't want to see me.
If you see your face.
Good afternoon. This is Judge Middleton. Who am I speaking with?
Roseanne Harmon.
Roseanne Harmon.
Oh, good afternoon, Miss Harmon. You're in the right place. You're a little early.
I know.
But it's okay to be early. Let me get
Better than
in.
late.
Right.
He's got to change your name.
I mute it.
No, you're fine.
Oh, okay.
I might mute you, but at that point, and sometimes it's hard for people to unmute, so.
Okay,
Right
all right.
now, we're letting the clock tick. Our first case is set at 1:15. The O'Donnell case is 1:25, and the Harmon case is 1:35. If the defendants log in early, we can always start early, but we used to set everything for 1:15, and the Supreme Court ordered us, which really was probably a good thing, that we set every case for a discrete time, so we set them about 10 minutes apart. I will let you all know that we are on the Zoom platform. We're broadcasting live on YouTube. Again, we started this morning, and these matters are being recorded. I will start when the defendants appear by advising them of their rights in the landlord-tenant proceeding. And you'll see how this works as we go through this. But right now, here is our 1:15 case.
Goodbye.
Good afternoon, Ms. Richmond. I think we're ready to start here.
All
Welcome
righty.
back to Michigan.
Oh, thanks.
We could use some rain. Could you brought some rain with you?
Is your lake low?
Quite.
Yeah, ours is too. I don't know how we're going to get our boat in.
Well,
I
let's
brought the
call
warm
this
weather.
case.
I couldn't bring rain, but I brought the warm weather.
All right, we'll take part of it. This is Terry and Larry Richmond versus Caitlin Jull, Jull. The file number is 21705. This is filed as a non-payment of rent case. At the time of filing, the rent was about $1,280 in arrearage. Bettina Emery is here from Keystone, our housing advocate, and maybe she got some insight into this. What's the status here, Ms. Richmond?
Okay, right now she owes $2,104.17. We've tried to contact her to contact Keystone, but we haven't heard back from her.
Bettina, have you had any contact from this tenant?
No, Your Honor, I haven't.
Do you know if she's still there?
Yeah, she was served personally there.
Yes.
Is that a good thing? I think I have a phone number, but when I call, they don't answer.
I don't have a number here.
You do have a number?
No, I do not.
Would you like one, Bettina?
Well, I don't,
May you send it to me in an email?
yeah,
me?
email it to her. Email it to Tina if you would. But I'm going to tell you what our options are.
Bettina, what is your email address?
It's B as in boy, E
Just a
M.
sec. I'll send it to you, Terry.
Oh, okay, thanks. That'd probably be better. I was just thinking I could call her.
Well, at any rate, here are our options. The defendant has failed to appear on a non-payment of rent case. She has been personally served. If she were here, I advise her of her rights, and she would have the right to a first 30-day adjournment. She isn't here. She's subject to default. As you know, you don't have to evict her on the 10th day, but perhaps that might induce her to contact Keystone to see about getting some emergency housing funds. So I'll give you your choice. I'll either continue this for 30 days or I will do a default judgment with a 10-day date for the writ.
I think we should do a default judgment because I can always work from her with that. You know, if she contacts Keystone, then we can work around that. I'll have 56 days to work around that.
All right. I find by default, she's only 3 minutes late at this point, but let's see here. The rent, that's through May, the figure you gave me, $2,104.17.
Yes, sir.
$2,104.17. We have a $110 filing fee and a $35 service fee, which is $145.
That's correct.
Plus $2,249.
That's what I think. That's what with the court cost.
Yes, 224917. Hopefully this will induce her to contact Keystone. The date for the writ would be 10 days from today, which would be June 5th. I've only calculated the rent through June.
Well, she got. Oh,
Or
okay.
through June 4.
If she contacts me, I'll have her call you, Bettina.
Sounds good.
Okay.
I'll send you that email address here before we're done.
All right.
If she logs in, I guess I'll ask you to stick around for just a minute.
Okay.
See if she appears. It happens so very often. I go through everything and then 10 minutes later the people log in.
Yeah, maybe they have problems logging in.
Well,
But I see some people don't.
no. Well, and I had a lady, she's coming up a little later. She logged in last night. She's logged in twice just now for a 3 o'clock hearing. I think she wanted to make sure she could do it. All right, now our next hearing isn't until 1:25, so we have to wait 4 minutes.
All right, well, I'll hang on. I'll just hang out here.
All right, we can't get very far without a defendant.
Nope. Can you get your boat in?
It's in, one of them is, it floats, so that's something. We'll
Yeah.
hope that we get some rain, I think, for the farmers need it more than the boaters, I think.
Oh,
but,
I know it. I thought we were gonna get some today, but it just got cloudy. It didn't go any farther.
All right, let's see what we got here. Well, we gotta wait a couple minutes. Mr. and Miss O'Donnell, is he still there?
Yes.
As far as we can tell, I mean, he's still there. We live right next door. I grew up in the home. He doesn't stay there though very much. He comes and goes once in a while. He
Now,
uses it more for
Is
storage.
it Jehosa?
I'm sorry?
How do you say his last name? Jehosa?
How do you pronounce it? I've always had trouble.
Find
with it.
out. Let's see what this
Yeah,
is.
Yeah, Giosa.
Josa. Yeah.
Sure.
Yes, I'm here.
All right, are you Jim Jehosa?
Yes,
How do you say your name?
that was perfect.
Okay. Let me give you a name. Do you have the ability to do video?
I'm not sure how I can do it on my iPhone. Can I do it on my iPhone?
You can. There's a little camera icon.
Let me look here real quick. Do I tell me what to hit, and I'll be happy to hit it.
GIOIOSA. GIOI.
Did I lose you?
No, I'm still here. I was trying to spell your name right. All right, this
Thank you.
is Judge Middleton. I'm here at the court in Centerville. Sean and Christine O'Donnell are here on the feed. They're your landlords. This is file 21708LT. This is filed as a termination of tenancy. You had a lease. It ended in February, and it's been month to month at that time. They served a notice to quit on you in April 3rd, and they're now asking for possession of the premises back. They were not able to personally serve you, but the service was attached. As a defendant in a landlord-tenant case, you have a certain set of proceedings, or a certain set of rights, and I'm going to advise you of those rights. As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, land contract forfeiture, or in this case, a termination of tenancy, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is not, Keystone could be able to help you. So this is not a non-payment of rent case. They simply want the property back. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If the parties are interested in such thing, the court can facilitate that. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. The plaintiff is asking for possession of the premises. The law requires that I set this for at least one subsequent hearing. And this is the first hearing. In a non-payment of rent case, the law requires I set the second hearing 30 days away. In a termination of tenancy case, I have to set the second hearing at least 7 days away. Mr. Josa, are you still there?
Yes, I am.
And what's your position? Are you willing to vacate or you wish to remain?
It was my understanding that on April 26th, I had paid the amount for May's rent, and therefore I thought we were going to continue with a month-to-month. I was asked to do certain things, and that was my understanding. The following day, landlords who have been very patient and good people, the following day said, well, the $1,300 you paid us last night actually isn't going to go toward May's rent. We'll put that toward the security deposit that was never collected throughout the year. And now you still owe May's rent.
The security deposit was collected, but the check bounced over a year ago.
We had
All right, well, let's
agreed
talk
at the
about
time.
this.
Sorry.
You filed the notice to quit on, I wrote April 3rd, yeah, April 3rd. Then you accepted rent after you filed the notice to quit, which complicates things.
In my eyes, it wasn't rent. We've been going round and round trying to get the security deposit, which would the check bounced over a year ago.
Well, in
We've
your
never
eyes,
got rent on time.
what the law says are two different things. But so, Mr. Giosa, you paid $1,300 on what date?
26th of April.
How much is the, and I don't need to know this, but the lease is here, and
12.
the rent was, I think, $1,200 per month. Now, they had $1,250 per month. The law requires that I set a second hearing. The acceptance of payment after the notice to quit is a complicating factor. Mr. Giosa, they had a difficult time serving you. Is this a summer resident or a permanent residence?
Permanent. I'm just not there every single evening.
Well, nothing says you have to stay home all the time. All right, the law requires I set a second hearing, which would be 7 days from today. So let me take a look at my calendar. 7 days from today is Memorial Day, so that won't work. So let's go to June. That doesn't work either. The next available court date is actually not until June 7th.
Your Honor, we'll be happy to pay June's rent while we're setting any date for the future.
Well,
We really just want our home back.
do that. If you continue to accept rent, it continues the tenancy. Mr. and Ms. O'Donnell, what you are seeking is to have this property back, correct?
Correct.
Correct.
Now, this is next door to their own house. I was just by there on Saturday.
Would the, sorry,
Go ahead.
I was just going to ask, I don't want to cause any ongoing problems for them. They've been good people. They've been patient. They've been fair. I'll, if possible, I'd like to pay for June, and then that would give me enough time to be vacated by the end of June.
Well, we could always do a consent. Mr. and Mrs. O'Donnell, would you consent that if he pays June rent and vacates by the end of June, that he can remain? If we go to June 7th, I would give him 10 days from June 7th, which would be June 17th. So you're only giving him 13 additional days. Do you have a position regarding that?
You want to
Let's go with the June 7th court date.
Yeah.
please.
All right.
The
Now,
thing
you
that
got a
concerns me the
problem.
most is,
If you want to consult with an attorney, you may have sunk your ship by accepting rent, so you're not willing to go 13 more days. You may lose the case and have to start over again. But I'll,
what do you think?
uh,
What do you mean? I'm sorry.
Yeah, repeat that.
Yes.
you've accepted rent after you filed the termination of tenancy.
In my opinion, and I have text to back this up, I told him over a month ago, the only way we do a month to month, and this was right when his original lease was up, he had some certain things he had to do. And the first one was to pay a security deposit that we never got because the check had bounced, and that has never happened. So when I accepted that payment, in my eyes, and I texted him back as soon as I got it, because one of the gentlemen that's living there that's not on the lease delivered some money up to me. And in my eyes, I texted him right back, said, you can stay the rest of this month, but this needs to go towards the security deposit, and then we need the rest of rent. That money, in my eyes, was going towards security deposit, and I informed them in a text. I can show you the text.
Well, what matters is not what's in your eyes. What matters is what the law says, and you're fumbling in the dark regarding landlord-tenant law. And you told him certain things which contravene the termination of tenancy you gave him. So
No, I told him that this money would go towards the security deposit.
Yeah, so you took additional compensation from him after you asked him to move.
I don't say, would it be additional compensation? It's original compensation, because we never got a security deposit.
It's replacing what bounced.
Yeah, and he's had pets living in there. I mean, there's
Dogs, he has another person living there.
Yeah.
This has been the biggest headache every month to get him to pay.
All right, they're not willing, don't pay any more money until this is resolved. This is regarding possession, not payment of rent. There's a difference between non-payment of rent and termination of tenancy. A termination of tenancy simply says they wish you to move. When it's a non-payment of rent, if you pay the rent, you get to stay. This is a situation where they want you to pay the rent and move anyway. So I'm not sure how this
No,
will.
it
No,
was
it's
a
not.
deposit, security deposit.
Yeah, that's one way to view it. Because the security deposit's going to be applied to unpaid rent.
no, he's paid up full in rent.
Well, that makes it even worse. All right, we will continue this to June 7th at 2 o'clock. Now, all things being the same, unless there's a motion to terminate this, you would have until June 17th, 10 days from the date of the hearing. But I would recommend that you don't pay any additional money until you vacate. Then you turn in the keys. Then you give your forwarding address in writing within 4 days of your moving. And then they file the security deposit notice regarding the condition of the premises and any unpaid rent. And then there's a hearing regarding who owes who how much money. So they allege a number of other things other than they weren't in the pleadings. They allege you have pets in there, unauthorized tenant. None of those were pled. They simply said your lease is up and we'd like our property back, and that is their right. So you can certainly consult an attorney to get some advice. Otherwise, I will see everybody here again by Zoom, and I apologize. There's no one here on Monday, and there's an issue with Friday. So the next available landlord-tenant date is actually 2 weeks. So you get an extra 7 days before we order the 10 days, just by the way the calendar falls. Do you have any questions, Mr. Giosa?
No, Your Honor.
All right, our next hearing is June 7th at 2. It will be by Zoom like this once again. All right, Mr. and Mrs. O'Donnell, you have any questions?
No, Your Honor.
No.
All right, we'll see you on June 7th. Thank you. All
Thank you.
right. Alicia, oh. Miss Richmond, you're good to go. It doesn't appear that tenant is going to appear.
All right, thank you very much. Hope to see you soon,
Okay, thank you.
in person.
Maybe.
All right, thanks.
All right, Ms. Harmon, let's address your case. It is 1:35, which is the appointed hour for this. This is file 21709 LT. It's entitled Roseanne Harmon versus John Harmon. This is a termination of tenancy case. Both are the same property, 17721 Hoschel Road. John is your brother or your son?
He is my son.
And he's got his camper on your property and you want him to vacate and he won't do it. So you
Right.
filed this termination of tenancy action and he isn't here. He was personally served.
Yes.
Is he still there?
Yes.
Who else is in the camper?
Well, he's living in the camper and then he comes into my house to use the restroom and to take a shower and then back out to the camper, and he has his friends come over and they drink and smoke and whatever else they're doing in there till all hours of the night.
Well, he isn't here. He's been personally served, so he's subject to default.
He said he was looking for an apartment, which is good.
All right. He has 10 days to move. If he were here, he'd get an additional, actually 14 days because I don't have next Monday or next Friday. He has until June 4th, or he's subject to being evicted.
Okay.
And you don't have to evict him on June 4th. You have 56 days from today. This is a strange case. It's not exactly a mobile home case. It's a, he's got his RV on your property. And so must remove, is it a motor home, a camper trailer?
Yes.
It's a,
No, it's a motor home, and he has a truck on my property also. And my daughter gave me a Durango, and it's in my name, but he like took it over, and he drinks and drives. What do you think I should do? Take it? Because he's got a really bad
if it's
temper.
entitled in your name, you're entitled to take it, but I'm not giving you any legal advice regarding personal property. This simply has to do with the tenancy. But with motor vehicles, whoever owns the title owns the vehicle. Now, he isn't here. Maybe he chose not to be here, or maybe he's planning to move. If he were here, he'd get his advice of rights, and then I would set a second hearing as required. He was personally served, and he is subject to default when he fails to appear. Let me repeat, on or after June 4th, you can come to the courthouse with $15 and ask for a writ of eviction. The sheriff would come forcibly remove him from the property. You don't have to do that on June 4th. You have 56 days from today to do it. But I don't know if he's prepared to move by June 4th, but I indicated June 4th and shall remove the motorhome. Anything regarding motor vehicles is beyond the purview of this hearing. So he probably will get this and call or something, I don't know, but he isn't here at the appointed time. He's, at this point, about 8 minutes late. I don't think he's coming. Do you have any questions?
No, I don't want to be mean to him because he is my son, but he's just got to go. I just can't
This
have
is
him
very
there.
common. It happens probably about once a month. A parent or grandparent just can't take it anymore and they pursue a termination of tenancy. There's no lease, he's just there, and you want your peace and quiet back, and this is the way you do it. So, you're good to go. We'll send you a copy of this in the mail. He has until June 4th to move, or he's subject to being evicted. And again, you have to follow through on that by coming in, paying the fee to ask for a writ of eviction. All right, you're good to go. Thank you.
Okay, thank you, Judge Middleton.
All right, Bettina, we have a hearing at 2, I believe it is, an emergency hearing on property versus Ewers. This was Mr. Barnes. It was a default judgment on a fail to pay rent. No, actually, it was a termination of tenancy. There is no lease. So she asked for an emergency hearing. So I don't know that you need to come in for that one. Unless do you have any input on that one?
She did contact me to see if she can get some assistance paying her back rent due to the circumstance of the termination of tenancy. I didn't believe at the time that we were able to assist her. So I want to be here to see if they are willing to work with her.
All right, I'm going to shut the recorder off. I'll leave the live feed on. You can, I'll just put you in the waiting room and let you know when someone comes in. Thanks for being willing to be here. Good afternoon. Who am I speaking with?
Arthur Owens.
You're for SNL Properties?
Am I? No, no, sir. It's in
What
reference
case
to my ex-wife, Miss Pauline Owens. Motion for honor and divorce decree and stimulus IRA. Did I dial the wrong number?
I think you want to be in Judge Patterson's courtroom. This is Judge Middleton. This is Landlord Tenant Court.
Yeah, but it has your name on here, Jeffrey, Judge, Referee, Magistrate, Jeffrey C. Middleton, May 24th.
All right, what's the file number?
File number. Is that the same as the case number?
Yes.
20402DM.
Boy, is that a mistake. That's a divorce case.
Yes, sir.
And what's the title of the case?
The title, it says, take notice. Oh, no. The title is Motion for Honoring Divorce Decree, IRA, and Stimulus Check. Basically, it would just, I wanted her to honor what the judge had told her. That's all that was.
Who are the
It's
two
the wrong
parties?
courtroom. Me and my ex-wife, former ex-wife, Pauline Jane Owens. I think he changed the name to Sarah Lee or something now. Sorelli.
And what's your name?
My name is Arthur Owens.
All right, let me see what I can find.
Okay.
I'm about to start another hearing, so bear with me here.
I'll
Somebody
take your
help
time, Your Honor. I know you're busy.
Well, you say you've got a notice with my name on it, and
You talking to me?
yes.
Yes, sir. Because when I filled it out, I had wrote Judge Patterson, and I guess they switched it.
All right.
I guess. I don't know. I don't have no other number to call except the one that I call. You could, if you could, have someone check with the clerk. Maybe he is going to hear it. I don't know.
All right. I don't have access to that part of his calendar. Can somebody help me here with Arthur Owens and Pauline Owens, file 20403DM? He says he has a notice with my name on it.
I have the same notice, Your Honor.
And you're Pauline Owens?
Yes, Your Honor.
Okay. Well, let me see what it is, because I don't have the file or know anything about it. So, Mr. and Mrs. Owens, I'm going to put you in the waiting room and we'll figure out what's going on here.
All righty.
I'm going to stop the record for a minute. If the others of you will just indulge me here for a moment.
Yes.
I have two people logging into my court, Pauline Owens and Arthur Owens, 20402DM.
Yeah, it's what to do with us.
Well, the notice has my name on it.
The clerk's gave them the wrong one then, to go out per. Can you give them an ID?
I'll have to do it on the record. I'll give it to them both.
Yeah. Do you have it?
Yeah, I've got it.
Okay,
All
thank
right.
you.
All right, thank you.
Bye.
All right, for those of you that are waiting for the emergency matter, give me just a moment. Pauline Owens is back and Arthur Owens is back. I checked with Judge Patterson's clerk and there was a mistake in the notice. I'm not sure how they put my name and number on there. I don't generally do divorce matters, if I can help it. The number to dial in, Mr. Owens, you have a pencil or a pen?
I'm looking for one. Give me a second. Yes, I have one. Okay, what's the number, Your Honor?
All right, Judge Patterson's courtroom is 445-049-8188.
445.
049 8188.
8188. And you will
Yes.
still use the number, still use the ID number? Or is that
Yes,
wrong
that's
too?
that's the ID number, 445-049-8188.
Your Honor, what do I
Okay,
use
when-
for the Zoom meeting?
That's the number.
Oh, this is the number to dial or this is the ID number?
445-849-8188. Thank you, Your Honor.
All right, okay. I'm not sure how that happened.
Yes.
I've never known it to happen before, but dial into
Right,
that
right.
number. They'll be ready for you on
Okay.
that side.
Thank you, Your Honor.
All right, thank you, sir.
Sorry about the
Bye-bye.
mix-up. Okay, well, that was a little diversion there, but, and I was confused, but that's not uncommon. We have, let me turn the record on. This is file 21555LT. It's entitled SL Property Solutions LLC versus Patrice Ewers. This is for a property at 126 North Main, apartment 8. Mr. John Barnes is here on behalf of SL Properties and their representative is here. Ms. Ewers is here. Also, Bettina Emery from Keystone, our housing advocate, is here. And I'm going to recite a little of the history here. This was filed as a notice to recover possession of property, a termination of tenancy. The notice to quit was served on the defendant on March 24th on a 7-day notice indicating she was to move by April 2nd. That was served on her. She did not move. Mr. Barnes filed a complaint to recover possession of the property on April 12th. That matter was set for a hearing on May 10th at 1:15. They alleged at that time there was no lease, but the rent was in arrears $4,612. The defendant was personally served with that action, and it was set, as I said, for May 10th. Mr. Barnes was here. The representative from SL Properties was here. The defendant, Patrice Ewers, was not here. Bettina Emery is here. Bettina indicated that the defendant had contacted Keystone regarding emergency housing assistance, but as the matter was filed as a termination of tenancy action, they were unable to provide financial assistance to pay the rent. But one of the confusing factors is, in addition to the termination of tenancy, defendant was also served with a demand for possession, non-payment of rent, by Mr. Barnes on March 24th, indicating that she owed $4,612.77. So there was a notice to quit and a demand for non-payment of rent, so belt and suspenders. So the defendant probably was confused. On one hand was a demand for non-payment of rent, and the other was a termination of tenancy. What was filed was a termination of tenancy. Just a minute, I've got somebody in the waiting room.
Hello?
Yes?
Hello? Yes, sir.
Yes.
I tried to get through with that 445-0498181, and they told me that number does not exist.
Eight 8188.
8188. All right. Thank you, sir. Thank you.
Thank you. All right. So we had a hearing on the 10th of May, and I was here, and Mr. Barnes was here, and SL Properties was here, and Patrice Ewers was not. So, and Bettina was also here from Keystone. So the date for the writ was 10 days later, which was May 20th. So on May 20th, the defendant sent a lengthy email expressing a bunch of things, asking to set the default judgment aside, essentially saying, I did miss my hearing due to my own mistake. I wish I had a better excuse than simply mixing up the days. I've been playing phone tag with Legal Aid and Keystone. I spoke to my landlord when he stopped by today, and this was dated May 18th. He did say if I'm able to pay my rent in full by Friday, he will waive the late fees and the eviction. So the defendant dropped the ball when she just didn't show up. Then when she's about to be evicted, she files a motion to set aside the default. There's a certain way that you do move to set aside a default. It's under the Michigan Code Rule 2.603D. A motion to set aside default or default judgment is based on a lack of jurisdiction over the defendant, which this isn't. If the motion to set aside is not based on lack of jurisdiction, it must be filed within 21 days, which this was. Then an affidavit of facts showing the meritorious defense needs to be filed, and there needs to be good cause shown for failing to miss the hearing. I'm not sure getting your days mixed up is good cause shown, and there is no affidavit of meritorious defense, although she had this long email about the deficiencies of the property. Mr. Barnes, thank you for appearing on very short notice. What's the plaintiff's position here?
It's my understanding the plaintiff still wants possession of the property. We had submitted the proposed writ of eviction, but I think the court held off because in the meantime it had received this request to set aside, so it's just waiting till today to decide where we go. The client would like possession of the property. We're proceeding on a termination of tenancy, not a non-payment of rent case. So there's no good cause shown.
Why did you serve her a non-payment of rent?
Well, when the case first started, the client wasn't really sure how they wanted to proceed, and then they just decided that, you know what, even if she pays up, we just want her out of here. You know, she's a lot of trouble. And so under those circumstances, rather than proceeding on the non-payment of rent, we just abandoned that and proceeded on the termination of tenancy and just skipped asking for a money judgment. And so that's what we did with the judgment itself. We just want possession. We're not asking for a money judgment from the defendant. So there is no meritorious defense because her saying, well, gee, I might be able to go to Keystone and get money doesn't make any difference because we're not asking for money here. And so even if she paid up, we're not letting her stay. So she might as well not bother trying to pay us money because the client just wants the property back.
Well, she alleges a number of deficiencies of the property and alleged that she was withholding her rent because of those deficiencies but nobody ever does it right.
Well,
And
that's-
if it is a non-payment of rent case, she's entitled to a CDC stay. And if it's a termination of tenancy case, she's not. So I understand why she's confused, but she goes to some length to just decry the condition of the property.
News to us.
Well, maybe I got it mixed up with a different case.
I don't think that's this case, Sharon. I think she's basically just submitted stuff showing that she thinks she could go get some money from Keystone.
Yes.
And that there, if it were a non-payment of rent case, that there would be a CDC stay, but obviously neither of those apply here.
Ms. Ewers, what's your position here?
My position is Scott told me to my face on the 18th that if I paid my rent, I could stay and he would waive the late fees. So I also have the, not the possession to quit, but the payment of rent, non-payment of rent paper from the same date on the, I think it was April 24th or March 24th. But I don't understand how it's not an eviction for non-payment of rent, especially when he told me just last week that it was.
Because he didn't know what he's doing. Have you paid your rent?
No, I've filed for assistance. I don't have a car. I'm looking for another job. I was doing a contracting job called Instacart. So I'm trying to find employment again. And I haven't really wanted to commit to anything if I didn't know if I was going to still be here or where I was going to end up.
Well, that makes sense. But yeah, for Mr. Barnes, for you to say, well, we simply abandoned the non-payment of rent, the tenant doesn't understand that. Plus, according to the defendant, your client contraindicated what the notice to quit said by telling her if you pay the rent, you can stay. Now, she doesn't have $5,000, but she could have asked Keystone for assistance if it was a non-payment of rent case. She also would be entitled to a stay. Now, the first notice to quit was to recover possession of the property, and that was dated March 24th. Then she also got a demand for non-payment of rent dated March 24th. So she got one of each. And I'm not, yeah. So then,
May I say something else?
just a moment. Trying to find the. The notice for hearing was strictly on a termination of tenancy, not a non-payment of rent, which is why Keystone wouldn't provide any assistance. Then you further complicated things by not showing up and on the 10th day sending me an email. So what did you want to say?
I did file for the moratorium and also for Sarah. I'm waiting on a call back from Keystone about uploading certain documents. That was all I wanted to add.
Okay. You got a notice to either pay the rent or move, and you didn't by, let's see what that date was. April 2nd. So you didn't pay the rent or move by April 2nd. So the landlord then filed a notice to terminate the tenancy. That was filed on April 12th. So there was nothing about non-payment of rent. They simply asked to terminate the tenancy. They wanted you to move. They said there was no lease, and they sent you a notice to quit. So you didn't in fact pay the rent, and then they decided they don't want to try to get rent, they just want you to move. So in a non-payment of rent case, you have the right for a CDC declaration moratorium that stays all evictions until June 30th. There's a considerable debate whether the Center for Disease Control even has the authority to do that, but they've done it and we've been following it. There are some cases challenging it. There's one on appeal right now. It says they don't have the authority, but for the sake of argument, let's assume they do have the authority. That's on a non-payment of rent case. Once again, when they filed the action on April 12th, they did not file for non-payment of rent. They just said they want you to move. So we had a hearing regarding whether you would move. That was on May 10th. You did not show up. You were personally served with the notice of the hearing, and so they asked for a default judgment, and I granted one. So there are two problems. One, there's no good cause shown as to why you missed the date, other than you were mixed up with your dates. Secondly, there was no affidavit of meritorious defense. If we tried to interpret your email as that, it's this stuff about paying the rent, then he certainly didn't help his cause. You're not under oath, so I didn't take any testimony or make a finding, but your representation is that even on the 18th, 2 days before the writ was supposed to enter, he said if you paid the rent, you could stay. The problem is Keystone can't help you in a termination of tenancy case. They're simply asking to terminate the tenancy. And so here we are. Mr. Barnes may have sent in the request for eviction. I don't have it in my hand here.
Let's see.
No fees were paid on the rent.
What are you saying?
No, the rent came in, but no fees, the $15 fee was
Oh,
not paid.
okay. We did get the writ on May 24th, which is today. But no, the $15 fee wasn't paid. So we do have the application for order of eviction, but the fee hasn't been paid. So
I'll
it came
go ahead
in
and
today.
I'll go ahead and forward that $15, Your Honor.
All right. So Ms. Ewers, again, if I guess you've already stated your position. What they're asking for is an immediate writ of eviction, as in tomorrow. As soon as $15 come, the sheriff comes and puts all your stuff out on the street. That's not very good. Your motion to set aside the default is denied. There is no meritorious defense, and there is no good cause shown as for why you didn't show up for the hearing. But I feel I need to give you some grace days to get out rather than have the sheriff come do the eviction tomorrow. Let me repeat, this was not filed as a non-payment of rent case. It was clearly filed as a termination of tenancy case. Keystone is not able to provide emergency housing assistance in termination cases. There is no lease. The rent is substantially in arrearage. The tenant elected to pursue a termination of tenancy. The waters are muddied up by your representation that he offered to accept rent, but that would be as if you had $5,000 in your pocket and you just pulled it out and gave it to him. But you're not able to ask for help with your rent the way they filed the case. If they filed a non-payment of, that's the irony of this, if they'd filed it as a non-payment of rent case, Keystone probably could help you, and they could collect probably $5,000 plus in delinquent rent. But they chose to file a termination of tenancy. So, is there anything else you'd like to say?
Not that I can think of right now.
Have you made any effort to relocate?
I don't have anywhere to go. That's one of the things I was talking to Keystone about. But if they can't help me because of how it was filed, then I'll figure something out.
I take zero delight in this. I've been evicting people on termination of tenancy cases that are going out to live in their car. I've had several in the last 2 months where the lease was up, the landlord wanted to terminate the tenancy, and I had to follow the law. I can't just let the tenant stay there without paying any rent. And Ms. Ewers, I hear this every day. I don't have anywhere to go. I would go somewhere if I had a place to go. There is nowhere to go. The housing is very tight right now. Every time someone's evicted, there's always somebody ready and willing to take that tenancy. But the true point of fact is no rent has been paid in several months, maybe 6 or more. The landlord, I'm sorry, go ahead.
I do have rent receipts, definitely.
When did you last pay the rent?
I've misplaced some of my receipts, but I do have them all somewhere here. The last payment, March 27th.
Last payment they show was in February.
March 27th, I have a signed receipt from the office.
They show the last payment was February 27th.
3/27/21, and then I have one from 3/20/21. I tried to tell them that the chart they gave me didn't add up, and I have more receipts than what they have on the paper. And I know I'm still behind, but I also don't understand the late fees if I never signed a lease, but I do have.
That's a good point. They can't charge late fees if you don't have a lease. So I don't know what the arrearage actually is. Total late fees, $1,085. They can't charge a late fee if they don't have a lease. So this is a mess. Done poorly.
Your Honor, we weren't saying there was no lease. There was a lease, but the problem was when she was in trouble with rent before, the landlord cooperated and sent the lease over to Keystone Place to help her get money to help her get caught up. Well, what happened was whoever was working with Keystone at the time lost the lease, and it didn't get sent back, and the person, when they sent it over to Keystone, didn't keep a copy before they sent it. So there was always a lease. It's just that it got lost when it went to Keystone Place, and it was before Bettina was there. Somebody else was there.
Worse and worse. They sent the original only copy of the lease without keeping.
Yeah, they sent the original lease and didn't keep a copy. So there was a lease. It's just that they lost the only copy by trying to cooperate and send it over to Keystone. So
When was that?
That was last summer, Your Honor, when
All
COVID
right,
first
so-
started and their first eviction diversion program started.
No.
Yes, and they did provide some assistance at that time, is that correct?
I am not aware if I don't believe they did because I don't think the paperwork got finished. But the previous manager here before me signed a lease with Patrice Ewers for Keystone to get her help.
May I say something?
Yes.
When Tim Brundage owned the building, I moved in here over 2 years ago. There was a year lease that I signed with Tim that was up already when they bought the building last February. I never signed a lease with SL Property Solutions. There was no lease with them.
Okay. And that sounds accurate. So you don't owe late fees, but go ahead, Mr. Barnes.
we're not asking for it. There's no money judgment here.
Right.
We're not.
They're not asking for money. They're asking you to move. And that's all it ever was after April 12th. There is no lease by your own admission. They bought the property from a previous owner. The lease expired. You never executed a new lease with the new owners. And so you were subject to a month-to-month tenancy after that. You've been struggling financially like many, many people have. And things are turning around. There are many places right now looking for help. But the true point of fact is there is no lease. They're not asking for back rent, even though he may have told you that on May 18th, which certainly muddies the waters. It's filed by Mr. Barnes as a termination of tenancy. Had they filed a demand for non-payment of rent, maybe the paperwork could have been done correctly this time. Who knows where the lease is? Anyway, it's a big mess. But I did find that there is no good cause shown for why you didn't show up other than you got your dates mixed up. But you didn't call the next day or the day after that or anything else. You waited until they were ready to serve the writ of eviction, and then you emailed me 10 days later.
Did I film that also?
And there's no meritorious defense. I'm going to, well, we have to wait for the filing. They haven't paid the fee for the eviction.
May I say something?
Yes.
I had contacted legal aid immediately. I left several messages with them, but my phone number was saved incorrectly, which I have the emails from them, from legal aid, showing that they put the 7 in the last 4 digits of my number at the end and were calling the wrong number. And that's why it took until the 18th to figure out how to file to waive the default motion to waive. Yeah.
Well, because of all the problems, I'm going to give you 10 days before I'm going to stay the writ of eviction.
Thank you.
Till June 5th. June 4th, that's 10 days from today. At some point, this shoe is going to drop. You don't have a lease, you don't have the money to pay the rent, and they want you to move. And that can't sustain itself. The rent is several months behind, they have their payment to make, so you're gonna have to make a provision to go. But I'm not gonna do an immediate writ of eviction under the complexion that this case is in. So I will, once they pay the $15 fee, I will stay the writ of eviction until noon, June the 4th. You can contact legal aid and they can attempt to file some other action, but your motion to set aside the default is denied.
Thank you for the 10 days.
All right. That's due to the confusion in his representation on the 18th of May. All right, you'll get a copy of the order denying the motion to set aside the default and staying the eviction until June 4th. All right, now, you may still wish to contact Keystone and see if they have any additional housing assistance they could provide you to try to find a place to move to. But the problem is it's hard to find a place to move to when you don't have any income. Do you have any family near here?
No.
I remember talking to you about this and about Instacart last summer. And
No.
so
Just started that. I only did it for a week. I was never in this courtroom before, ever. I've never.
All right, then it was some other young woman who was doing that also. At any rate, as I said, you don't have a lease, you aren't paying the rent, they want their apartment back, and it really boils down to that. All right, you have 10 days. I'll send you a copy of the order.
We'll get the fee over to you, Your Honor. Thank you.
All right, thank you.
All right. Thank you, everybody. Bye.
Bettina, thank you for staying. Patrice, do you have the number at Keystone?
I do, yeah.
I suggest you call them. Bettina's waited patiently to go through all this. She's aware of the circumstances. They would probably help if they were able to, but perhaps they've got something else that could assist you.
Okay. I don't know if she got my voicemail that I left after we last spoke. I was having some trouble uploading the documents, but I will call her today.
Okay. All right, thank you.
Thank you.
All right, we're gonna pick up a couple of difficult small claims cases in a half an hour. In the meantime, I'm gonna do the difficult order on the case we just did. So we'll stop the live feed and